appeals in the matter of Lee and other long leaseholders and the Ilfracombe Management Company Limited and others.
Yes. Yes, Mr. Bates. Can I just indicate we've read the papers? We have, we think, a lively appreciation of the issues. So do take your own course. But as I say, you can take it that we've read everything.
My Lord, I'm grateful for that. Then you'll know this is a second appeal on costs. It engages Rule 13(1)(b) of the 2013 Tribunal Rules, and I act for 195 appellants against the respondent represented by Mr. Bates and Mr. Abadian. My Lords, in essence, we say three things. First of all, that Judge Cook erred in principle in applying the wrong test, i.e. applying that set out in Willow Court, which we say is not the correct test, or at least not a comprehensive statement of the correct test. Furthermore, and in any event, even if it is, that Judge Cook failed to take account of the fact that the FTT below had ignored or overlooked key relevant factual findings made in the substantive determination. And then thirdly, we say that Judge Cook, in upholding the FTT's decision, was seriously wrong because the FTT, in exercising its discretion, reached a decision which lay beyond the wide ambit of conclusions that were reasonably open to it. And the point of principle under CPR 52.7, the important point of principle that arises is what is the threshold test for the FTT in determining whether the bringing, defending or conducting of proceedings has been unreasonable, such as to engage the FTT's discretion to order costs against a party.
Yes.
My Lord,
and you refer to Judge Cook, and obviously the decision of the UT is of some relevance, but like all second appeals, what we're really interested in is the decision by the First Tier Tribunal.
Indeed.
Because if that was wrong or a decision that no reasonable tribunal could have reached, and in a sense, it doesn't matter what Judge Cook said.
My Lords, yes, and I was going to take you in chronological order, in fact, through the judgments. In other words, starting with the substantive determination, then the cost determination, and finally, very briefly, to Judge Cook's decision. But what I want to do to start is to just refer you immediately, I'm sure it's entirely familiar now, to the rule itself, which is in the authorities bundle at tab 5, page 14, page 13 and 14 and 15. It starts at the bottom of the page there, subject to 1ZA, which is not relevant. The tribunal may make an order only under section 29(4), or if a person has acted unreasonably in bringing, defending or conducting the proceedings. So two alternatives. It's right to point out that the rule as set out here is slightly different from the rule that was being considered by both the FTT and the Upper Tribunal, not in a material way, but we've included in the bundle the amendments that came in page 17 and 18 of the bundle, tab 5, the amendments that came in 2022, in November 22, so after both of the decisions, which effectively omitted words which we will see when we come to look at the decisions themselves, because they include the words, but they're immaterial for our purposes.
So
they remove references to the three tribunals that were referred to, and simply say that in all tribunal cases, a person may be liable for costs in the circumstances identified. I mean,
So is this just removing subject to paragraph 1ZA?
No, it isn't. No, sorry.
Which bit are you? That's the sideline.
Can I take you to Willow Court, which sets out the rule as it was in these appeals. In these hearings. Same rule. This is page 25 of the bundle's authority, page tab 7. If you look at paragraph 10, you'll see that the rule, that's the old rule, pre-November 22, and what's been taken out are the words under B, after proceedings, the words in an agricultural case, a residential property case, or a leasehold case. So those three sub-paragraphs have been removed by the relevant changes. But as I say, the FTT's decision was, of course, much earlier, but the Upper Tribunal's decision was June, and the new rule came in November of 2022. But I don't think it makes any material difference to the issues on the appeal. And just to be clear, the exception that has always existed, as you see in relation to land registration cases, is retained. In other words, the land registration division of the FTT, formerly the land adjudicator, has always had a discretion, a wide discretion to award costs, unfettered by the limitations provided in sub-rule B. My Lords, just to be clear, what I intend to do over the course of the next hour or so is, first, I would like to take you to the key paragraphs of the FTT's decision. Secondly, then, to say something about the statutory background and the wording of the relevant rule, Rule 13. Thirdly, to address specifically the threshold test as propounded in Willow Court. And fourthly, then, just to return to the grounds of appeal in this particular case. My Lord, if I can take you first then straight away to the decisions, and in particular starting chronologically with the substantive determination, which begins at 65 of the hearing manual. And my Lords, I appreciate that my Lords are familiar with the decisions. One point I did want to just make, however, by way of addition, is that you will have seen that there is reference to a claim to rescind these leases, which was going through the court at the time that both of the decisions were made. In fact, all three of the decisions were made. I should indicate to the court that judgment in that matter was handed down last Friday. I can give you the neutral citation reference, if you like, and I have copies of the decision. That was a case heard by Mr. Justice Foxton, who determined, amongst other things, it was a test case. There were, I think, over 400 claimants. There were 3 Ilfracombe leaseholders, so this is a wider allegation of fraud. 3 Ilfracombe leaseholders were subject to the test case heard by Mr. Justice Foxton over 10 weeks last term.
Over how long? So heard over
10 weeks last term.
10 weeks?
I think so, yes. I mean, there were...
Sorry, I didn't say blimey. I just said... that's quite a long trial.
I have to say, I wasn't involved in the trial, and this knowledge comes through me via my solicitors who were involved in the trial, though not the team that sits behind me, involved in the trial for the claimants, obviously. The judge determined, amongst other things, that the Ilfracombe leaseholders were entitled to rescind their leases because of fraudulent misrepresentation and deceit. The terms on which that will occur have yet to be worked out. In addition, the learned judge found that there were breaches of FISMA, the 2000 Act, and held that this was an unregulated collective investment scheme, or part of one, making the leases unenforceable and the investors entitled to the return of their purchase, of the purchase prices they paid. Now, my lords, I fully accept that, of course, that could not have been known by the FTT or the Upper Tribunal.
It's immaterial for its background, but it's immaterial for our purposes. Yeah.
My lord, certainly as far as the narrow issue is concerned.
Yeah.
Having said that, as Judge Cook pointed out in paragraph 48 of her own judgment, if one views this as a fraudulent scheme, as the lessees do, then of course the bringing and conducting of proceedings relating to service charges must appear outrageous. But the FTT carefully and correctly put all that out of its mind.
Can we just, for my benefit only, just how this works? If we decide that the FTT got it wrong, so that we set aside their ruling, are we then limited to the information that they had at the time?
My lord, no.
In which case, is it irrelevant?
Well,
Justice Foxton has made these findings.
And my lords, I made it clear that I was saying it was irrelevant to the narrow question that is raised of principle in this appeal.
The question of law.
But if, my lord, you're absolutely right.
If we get to the stage of taking the decision for ourselves,
indeed,
you would say it's relevant.
I would say it is relevant. It would just be almost absurd to ignore it. It wouldn't be in the interests of justice, in accordance with the overriding objective, simply to put that to one side.
Well, we won't look at it now, but presumably, therefore, we need to be furnished with the judgment, perhaps at the end of the hearing, and with the relevant paragraphs marked up and identified. So I imagine if it was a 10-week trial, it's not a short judgment.
170 pages.
170.
70.
Oh, well, that's quite short.
If you get it
after
to
10
us
weeks.
by lunchtime. I mean, I hesitate to disagree with my lord about anything, but there might be a case for saying that we should have it before the end, because Mr. Bates may wish to say something about it, and we wouldn't necessarily understand what he had to say if we didn't have the documents. So if copies of the judgment are here, speaking entirely for myself, I think I would prefer to see it before we get to the end.
My lord, they are here, they're hole punched and clipped, I think. But I haven't marked up the relevant paragraphs. I can give you the relevant paragraphs. I can tell you which they are.
Well, shall we, my lord is quite right, shall we work on the basis that you'll provide that when we rise for lunch, and if in the meantime somebody can identify the paragraphs
yes,
relate to Ilfracombe, then that would be
my lord, what I will do, if you will just give me one moment, is to pass my copy back where I've marked the paragraphs myself. If I can hand that back to my instructing solicitors, then they can be doing that whilst we proceed this morning.
Okay.
Has anyone asked for permission to appeal?
I don't think we've got to that stage yet. There's a hearing
To come.
because the terms on which rescission is going to be ordered.
There's a consequentials hearing,
Yes, exactly.
which doubtless will be just as hotly contested as the original hearing, as consequentials hearings tend to be.
And there's an added complication which you may have picked up from the judgments that you've read, which is that Tuscola 106, Mr. Gouvet's companies, have an interest, and therefore the judge directed that they should be attending and represented to make submissions, should they wish, on the question of terms for rescission. So it's not straightforward, although rescission has definitely been awarded.
Yeah.
And of course, that's just 3 claimants, but one knows how things work in these types of claims. I can say on instructions that all 192 other appellants in this case will be seeking rescission of their leases as well.
So the 3, did you say there were 3 Ilfracombe leaseholders, were those just, as it were, chosen at random as representative claimants?
Yes, I think so. I can give you their. Well, we'll identify on the front cover or somewhere which three it is.
Okay.
At least one of them gave evidence, but there was obviously a much wider. I mean, much of the judgment doesn't really concern Ilfracombe at all.
Well, that's what I suspected, which is why I asked for the paragraphs to be identified.
Which my lords, I promised to do.
Yeah. So that was the background, and then I think you were coming to tab 8.
Yes, page 65. Mm-hmm. And this is the substantive decision. And my lords, can I just take you very quickly to a number of paragraphs? I'm going to assume that it's reasonably familiar. Just to note on page 68, paragraph 10, that Mr. Cooley and Mr. Spence, who were defendants 1 and 2 in the fraud action, were observing at some points, although took no part in the proceedings. In paragraph 16, the tribunal pick up the apparent conflict of interest that Mr. Goubet has. And then, if I can go on to, I think I can take you straight to paragraph 34, which is on page 71. Mr. Goubet explains his position, and he confirms in the last sentence he had no control over Cooley and Spence, who were the directors at this time of the applicant company, and would prefer that they were not directors of the applicant. He stated he would not advise anyone to pay any monies to any entity controlled by them. And then in 37, he confirms he had audited accounts for 2020. In his evidence, he said he was not required to give the management figures he worked from. The budget was calculated from the knowledge he had at January 21. And then over the page at 40, could I ask you just perhaps to read 48 to 50 on page 72?
Sorry, give me those numbers again.
48 to 50 on page 72.
I think that's later referred to as eliciting dialogue.
Yes, exactly. Bringing to the table, bringing people to the table. That's the purpose of the. He states candidly the purpose of serving the demands based on the budget.
Yeah.
And then 65 over the page, Mr. Goubet explains his involvement in paragraphs 57 and 58. The last sentence of 58, he explained his Tuscola companies had loaned money to the service charge account and not the applicant company. He stated all monies were in a ring-fenced client account. And then 65 to 66, towards the end of the page,
I mean, that's his evidence.
That's his evidence, not a finding. And then the key, just over the page, then to 74, before we come to the key points. Sorry, not 74, over to 75 to the decision, paragraphs 86 to 88. In particular, paragraph 88, the case was unusual. Mr. Gubby appeared to state at points he'd been the victim of a fraud. Mr. Gubby was supposedly in attendance as the representative of the applicant, having been authorised by them. It was the case that Mrs. Spence and Cooley ultimately controlled many of the companies referred to within the proceedings. And then over the page at 90, we find, as a matter of fact, that generally in presenting the case, Mr. Gooby, while supposedly representing the applicants, in fact presented a case which reflected his own interests, including those of Tuscola. This is a finding we have regard to. And then at 93, perhaps I could just ask you to read 93, 95 and 97. 93 down to 97. My Lords, then over the page, the key findings that we rely on are at 77. Could I again just ask you to read 98 to 103?
Yeah.
So, my Lords, what we emphasise, therefore, from those paragraphs, first of all, a finding of deliberate failure to disclose reports and other documents which existed and without any proper reason offered. That's the first point. In 101, para 101, that the budget had been set or approved by the applicant without a genuine belief that the sums were those required. In 102, there was no evidence and no real explanation from their agent, the applicant's agent, Mr. Goubet, of how the figures were calculated or how responsibility had been divided between the blocks. And 103, that the budgets had been set without having regard to any reasonable costs. And then, my Lord, just over the page, 107 and 108. Mr. Gubby's position is explained. And then just at 112 to 114. In particular, Mr. Gubby at 114 repeating his position that he wouldn't advise anyone to pay any money to a company controlled by Mr. Cooley and Spence, i.e. the applicant, not appreciating that that was what he was asking the tribunal to do on their behalf. And then finally the 115. And 116 on page 79. And my Lord, as regards Mr. Gubbay's
Well, 116 is the sort of the final conclusion, which is that none of the claims were reasonable.
Yeah, exactly. And what that shows is that the applicant, in that case, was allowing its representative, Mr. Goubet, to conduct the application in circumstances where it implicitly must have known of the conflict and of Mr. Gubbay's own agenda in seeking to take control of the applicant. I mean, in that sense, the application appears to be something of a sort of proxy battle rather than one designed to determine the reasonableness or otherwise of
Well,
the
the
budget.
tribunal didn't make any findings about that.
No, they didn't. That's,
And indeed, what happened was that there was the application to withdraw the application following his dismissal as a director,
yes.
followed by an application to withdraw that application. The judge says, press on. And then the next day, they appointed him as their representative.
Indeed.
So we don't need to go there, do we?
No, my lord, I'm grateful. And then, if I could take you then to the next judgment, the cost decision at 87.
Yeah.
Page 88, the tribunal set out, and in fact there you can read the rule as well, as it stood at the time in paragraph 5.
Yeah.
And then if we can go to paragraph, page 91, paragraph 19.
Well, that was the argument.
Yes, that's recorded as the submission made by my predecessor.
Yeah.
If it were necessary, would you submit that where someone in these circumstances puts forward a budget in which they have no reasonable belief, that of itself constitutes vexatious and harassing behaviour?
Yes. In bringing proceedings based on a budget, and indeed one could say conducting as well, based on a budget.
So even if we were to decide that demonstrating vexatious or abusive or harassing behaviour was a necessary constituent part of the test, you'd say it's clearly passed anyway.
Indeed, yes, I would. And the problem is that the tribunal, the FTT, lost sight of that finding, although it was put to them. I mean, it says Mr. Verdun suggested, but presumably he was saying, you found that. So it was clearly put to them. And of course, one bears in mind that neither this hearing nor the hearing before the Upper Tribunal was the applicant, respondent represented.
They were at the previous hearing.
At the substantive.
And the FTT, not unreasonably, it's not a criticism of them, get a bit muddled about that. For example, in paragraph 31, they say it's common ground between all the parties that there have been significant fraud. Well, that wasn't common ground with the applicant, but they weren't represented at the costs hearing at all.
No. Made no representations at either of the costs hearing.
No. So as a matter of fact, there was no explanation, reasonable or otherwise.
Exactly. And we see in 29, on page 92, Mr. Allison, who represented Mr. Goubet and Epworth, confirmed he didn't represent the applicant and accepted the conflict of interest.
Yeah.
And then, just over the page at 93, this is a submission for Mr. Goubet, but it's something that I think is relevant because it's picked up in the decision. Mr. Allison suggested at its heart this was a straightforward application for a determination of estimated service charges. In his submission, the issues to be adjudicated were straightforward as the dispute has now been resolved. I don't know how that latter point was made, but one sees that the tribunal pick up on that.
Well, I assume that meant the dispute has now been resolved, the applicant lost.
Yes. Yes,
Yeah, but
the
a more
application has...
straightforward example of resolution of a service charge dispute would be the tribunal ending up with a number.
Yeah.
And here there was no number because it failed in limine.
It failed in limine, and I mean, sometimes in these cases, particularly where you're asking the tribunal to determine a budget that you haven't demanded for necessarily, or you are going to demand for, the tribunal will helpfully say, well, that's an item that is reasonable, that isn't. Or those costs.
The schedule, you go through it and you end up with a number.
You end up with a number, or an indication sometimes, rather than simply a finding, but an indication that looks.
But it goes together, doesn't it? It's one, it's put forward without any belief in its truthfulness or validity, and two, the express finding in 116 of the substantive judgment that none of the budgeted, not one of the budgeted amounts was reasonable.
Yes, not one.
Not one. And that strains the suggestion that this was a straightforward application.
Yes, indeed. And that's the point that is made by, to be fair, I think the point made by Mr. Verdun in saying on both here and I think on appeal, where he says the FTT took a too narrow a view,
Yeah.
the narrow focus point. And of course, where you're applying for costs in any jurisdiction, whether the issues are straightforward or not is largely irrelevant. I mean, this could have been the most complicated case involving, as they sometimes are, involving, as this did, millions of pounds, but where you have expert evidence on whether a particular method of repair is appropriate, you have evidence, complicated issues arising as to lease construction, very unstraightforward cases.
Yeah, but that's just a distinction between something that's not straightforward because it's complicated and something that's not straightforward because it's not bona fide.
Well, yes, but the point I make is that the tribunal seemed to have said this was a straightforward case because it was a simple case of looking at the lease and then looking at the budget and deciding that these sums were not reasonable. But the fact that the issues themselves didn't trouble the tribunal much in the sense that they determined them apparently easily and quickly is irrelevant to the question of costs, because the rule makes clear it's about bringing and conducting, not about whether the issues themselves are complicated and have taken up a lot of court time or were unarguable as issues or whatever it may be. So then the focus, the narrow focus point was, in my submission, a good one. And then if we can go on to 48, this is where the decision starts, page 94, paragraph 48. I should point out actually that, of course, at 35, on page 93, Willow Court is referred to. So that was clearly drawn to their attention, as was Ryder and Horsfield.
Yeah.
And then over the page, 48, this is an unusual case.
Yeah.
And then to the key decision page, which is 97, page 97, it's the paragraphs 64 onwards.
Well, just before we get there, the paragraph 61 says we now turn to the Rule 13 applications for costs against the applicant, Mr. Goubet and Mr. Epworth. And then 62, Mr. Allison suggests that no orders should be made against Mr. Goubet and Epworth, and then goes on to address that aspect of the case. And so you were taking us to which 60?
I was taking you on. Yes, my lord, you're absolutely right. There's a legal argument raised about whether, because Mr. Goubet was a representative, he ought to have been in the wasted costs provision, which hadn't been mentioned. So it's a technical point being taken.
Yes.
And the tribunal decide that no, even though he's a representative, he's a person under B, and as the application has been brought under B, they can proceed with it.
Yes.
I mean, I have to say,
But then it goes on to again to deal with Mr. Goubet and Epworth.
Yeah, exactly.
I mean, long story short, the only two paragraphs actually dealing with the applicant are 74 and 75.
Exactly. That's the point.
Although obviously some of the general stuff, it might be said, is not irrelevant, such as, I don't know, 67.
Yeah, and in 66.
But it's not a criticism of the tribunal, because this was an unusual case, but there was a bit of a muddle as a result of Mr. Gubay and Epworth being represented, but the applicant not.
Yes, that's absolutely right.
And one might have wished for the costs applications against each of them to have been dealt with separately rather than under one, slightly darting about. But that's only the complaint of a Court of Appeal judge, because it makes it slightly harder to work out actually what's going on. It's not a substantive complaint.
No, I mean, that's a fair point and a fair criticism. It has to be said, of course, that the submissions that Mr. Allison were making were not on behalf of the applicant, and that's what the tribunal were addressing. And I think it's fair to say, understandably perhaps, that my predecessor therefore concentrated on those submissions rather than on the position of the applicant.
Well, the central finding that you've got to knock over is 75 line 5. The application was, in our judgment, a reasonable course of action.
Yeah, absolutely. And
because if that stands, then you're looking at scraps.
Yes, although of course that's dealing with the bringing of the application.
That's what I meant.
Yeah, not the conduct of the application, but of course.
But you're not going to get all your costs back if you're limited to particular you're less likely to get all your costs back if you're limited to procedural aspects which went wrong or were not what you might hope to see.
Yeah, and of course we say that's just really, and again one appreciates the difficulties that an FTT faces in this type of complicated case. That was a finding that really wasn't open to them. It was an irrational and I would say perverse finding in light of the fact that the bringing of the proceedings were based on demands in respect of which the applicant had no genuine belief in their accuracy.
Can I see if I've understood this chronologically? The demands went out in January 2021?
Yeah.
And the application was made on the same day?
Or the day after. It was served on the day after.
At that point in time, Mr. Gubay was the director of the company.
Yeah.
That was the company acting.
Yes.
He was not removed until May 2021.
I think that's right.
17th of May,
Yeah.
I think we're told. But then following the little procedural wrangle about withdrawing the application in September, he's appointed by the company as their representative on the 10th September.
Yes.
And the proceedings, the hearing takes place in September.
Yeah.
So when one's talking about the bringing of the application, that was Gubay acting as a director.
Yeah.
Did much happen in these proceedings between May
and September?
Well, there was the little wrangle about whether the application was withdrawn, but the tribunal dealt with that by making an order for costs.
Yes, I think...
Was there much else in the way of costs? They didn't prepare a bundle.
No. And
your solicitor had to prepare a bundle.
Indeed. Lord, I think there was an issue, and can I just check this? I didn't appear at the hearing. I'll turn round if I may. There was an issue about Mr. Gubay having signed, I think, a statement of case without authority, in the sense that he wasn't a...
Well, I think he signed the application.
Yeah.
But that was in January.
That was January when he was director.
That was just said to be a frolic of his own. But surely the point is that although Mr. Gubay was removed in the way that my lord has said, the company, the applicant, was a properly constituted company. So it's not the situation, or akin to the situation one sometimes gets in litigation, where you suddenly find a company's been struck off.
Yeah.
The company was always properly constituted.
Yeah.
It had those two gentlemen as its directors, and people may have done things wrong, but the company has to carry the can.
Yes, exactly.
But indeed, my Lord Justice Coulson was asking about the bringing of the action. But is it right to see that in this context? That was at the time when he was a director, he signs the application and so on. And the findings you're relying upon by the tribunal, or substantively, is that the demands were not properly made at all.
Yeah.
They were not genuine, based on a genuine estimate. Everything that followed thereafter followed from that initial problem.
Yes.
That's the right way of describing it.
Yes, I think that's right. And
So we can see why the tribunal focuses on the bringing of the action.
yes,
It was,
indeed.
in a sense, doomed to failure.
Yeah.
Unless, for example, the applicant was then suddenly going to produce the documents they never produced, i.e. the estimates, to show that they were reasonable.
Indeed.
But they never engaged with that.
No, and the latter point is relevant is the key point on conduct, because it's not just a case of not disclosing documents through inadvertence or negligence. It's the tribunal find that those documents were available to the applicant or its agent and were not disclosed.
So, speaking for myself, when I read the cost decision, although, as has been pointed out, there are a couple of paragraphs at the end which deal with the company. Again, it goes back to the bringing of the action. It's in the context of the earlier findings about the reasonableness of the bringing of the action.
Yeah.
That starts off with Gubby et al., but logically it would seem to apply to the company.
Indeed, absolutely. The company acting through its agents, but it takes the can for the agents' actions. But my Lord's absolutely right that no real separate consideration is given to the position of the applicant. In 74, the point is made correctly. I mean, I have no problem with that paragraph, simply because the applicant took no part. It does not automatically follow that an order could or should be made. No problem with that. I mean, clearly it's a factor to be taken into account on a costs hearing if an applicant doesn't appear and is not represented without any apparent excuse. But the tribunal then, having made that proper observation, go on then simply to say, overall, this tribunal finds the conduct of proceedings, save as dealt with below, such that no order should be made. Mr. Gabay against the applicant, Mr. Gabay or Mr. Or Epworth. We do not find that the overall conduct of these proceedings was unreasonable. The application was, in our judgment, a reasonable course of action. So that means the bringing of the application. Because there was, and the reason that they pick up on that the reason they find that is because it was a straightforward issue to be addressed. Well, I've made the point that the issue, whether the issues were straightforward or not, is not relevant to the costs issue. And it's right to point out that they do then go on and make a small finding against the company applicant in relation to the bundle and the withdrawing of the application, or sorry, the application to withdraw and then the withdrawing of the application to withdraw. So by laws, very simply, the tribunal failed to take account of the fact that a knowingly disingenuous budget had been set by the applicant, and thus disingenuous demands had been made on the back of them, some of which were paid, I'm told. It cannot be said, in my submission, reasonably, having made that finding, that the bringing of the application was reasonable. As far as conduct is concerned, conducting of the application, in particular, the disclosure point is absolutely key.
Well, the disclosure point comes back, as my lord has put to you, that comes back to the making of the application. Because if you're making a bona fide application for service charges worth 2.4 million, in your application, you provide your supporting documents.
Yes.
I mean, you don't come along later.
No.
With that stuff, you tend to want to have it front and centre. So,
absolutely.
As my lord indicated, I think you do come back to the same points. Really, Mr. Hutchings, I mean, I'm not looking to shortcut anything, but in one sense, your submission comes down to this, that there is a significant disconnect between the substantive judgment and the findings made and the cost judgment.
Yes, exactly.
Almost as if they had forgotten the findings that they'd made that you've just taken us to.
Indeed.
Particularly 96 to 103 and 112 to 116.
Yeah, absolutely.
Can I just ask you one thing, because I just don't know. In this, my lord has just said, if you're making a claim for 2.4 million service charge, you undoubtedly would expect to have documents. But is it, as a matter of normal practice in the real world, when service charges are demanded in the normal way, do people normally provide the supporting documents?
Certainly in the sort of cases that I've dealt with, which tend to be on the larger
What's
scale.
in the grandest of cases?
Well, no, I'm not trying to say that. I did start doing these cases before the LVT many years ago, when much smaller sums were involved. But yes, I mean, normal. Yeah.
I mean, one would expect that if you thought it was going to be contentious, you'd put your best foot forward and you'd put your supporting documents.
Absolutely.
Yeah.
Absolutely.
Some of these were described as major works.
Yes.
Were they capital works in nature? As opposed to normal repair?
Oh, yes. I mean, this was...
There were some blocks which were going to be practically rebuilt.
Yes. In fact, I mean, part of the selling of the fraudulent selling was on the basis that there was going to be a total revamp of Ilfracombe. I think it was unusual in that sense as regards the other frauds, which were about new builds, I think. But this was a revamp, and that was how it was sold. So capital cost...
Does the legislation impose a requirement for consultation with lessees?
Oh, yes, yes.
On works of substantial nature?
Yes, indeed.
So would that not normally yield estimates in advance of any proceedings?
Of course, when you serve your consultation notices, you back it up with documentation.
Did that happen? Did that happen in this case?
Well, my lord, I have to say I don't know. Can I just
Someone who's clearly involved in the case at the back thinks it didn't.
Well, that's missed. Yes, that's one of the 195.
I mean, the whole point of starting proceedings is you start proceedings if there's a dispute. There's quite a lot of law about is there a dispute. If you're doing it the day after you've sent out the claim, in another field of endeavour, that would not be regarded as a dispute having crystallised. No, anyway, yeah.
Yep.
Yes, but that's absolutely right. And of course, the overriding objective applies. Rule 3 of the tribunal rules incorporates the overriding objective. I mean, obviously, the protocols of the CPR do not directly apply, but you know, one observes the spirit. Ordinarily, as a landlord, this is not a penurious, or at least it's not a small landlord. And sometimes these cases do involve very small sums, and small landlords make errors. But this is a different order of things, and that could have been and should have been taken into account. Yes. So I mean, just to sum up, really, the bringing of the proceedings, 3 key findings: not a genuine budget. Calculated, and this is in a sense a stronger finding, calculated not, the budget was not calculated having regard to any reasonable cost.
Is that relevant because it's a statutory requirement that the cost be reasonable?
Yes, it is, section 19. But it's that emphasis that I emphasise the word any reasonable cost. And the evidence showed that Ilfracombe, by its directors, had allowed its agent to bring the application precipitously, with the company itself, and this was another finding at 99, with the company itself having, quotes, little or no idea what was actually going on at the property. That's paragraph 78 on page 99 of the cost judgment. Well, sorry, the directors of the applicant, Cooley and Spence, had little or no idea as to what was going on the property. And the justification of the application candidly given by Mr. Gooby was that he was trying to bring people to the table. And those three factors were not addressed at all by the FTT in deciding the order that they made. And then as far as conducting is concerned, it's the disclosure point, deliberate. I mean, I would also add that allowing its agent, Mr. Goubet, to act in the proceedings where there's a conflict and where its own agent was openly accusing it of fraud, it meant inevitably that the proceedings were effectively frivolous. To allow, to bring an application where you're...
Did you say frivolous?
I said frivolous.
That's worse than that.
Well...
It's abusive.
Abusive.
And vexatious. I don't mean frivolous suggests that someone might smile.
Well, that's true.
To some extent. Yeah, okay, I'm sorry.
No, my lord.
Pick you up on that.
No, thank you. That's a fair, very fair point, if I may say. My lord, I don't know whether I need to take you particularly to the Upper Tribunal decision.
Speaking for myself, you don't. If there are any points about it that we need to take into account, then Mr. Bates can raise those and you can reply. But yeah. As I say, this is a case as to whether the FTT erred in law.
Yeah. And
you made it quite clear that your ultimate submission is that the conclusion on cost was perverse.
Yes.
We get that.
My lord, can I just, perhaps one point in the judgment, and it's a point that goes to my next, the next topic I intend to cover, which is the statutory rule and its history. But if I could just take you to page 40, which is paragraph 34, ground 1 of the grounds of appeal. The learned judge says the first ground of appeal is that the FTT applied the wrong test. It referred to, quotes, the exceptional circumstances envisaged by the rule, that there is no threshold of exceptionality in Rule 13. And the judge dismisses that as unarguable. But my lord, in my submission, that was somewhat unfair. If we go to 97, page 97, we can see precisely what the judges said. It's paragraph 64. In our judgment, in the context of tribunal proceedings, often conducted by non-legally qualified reps, it must be correct that they may be a person within the meaning of Rule 13 and against whom an order for cost may be made in the exceptional circumstances envisaged by the rule and endorsed in Willow Court. So, in my submission, the first ground of appeal, which said that they'd applied the wrong test, an exceptional circumstances test, was actually a fair point to make on the wording of that paragraph.
But isn't there a danger of getting too, potentially at any rate, getting too semantic? It's an exception because this is a cost-neutral regime.
Yeah.
But there is an exception to that if somebody either brings proceedings or conducts proceedings unreasonably. So it is, to that extent, an exception.
Yes, I mean, yes, the semantic distinction between an exception and exceptional circumstances, the two are very different.
But if you read that in context, surely it's justified, because the point that they're making, if one looks for the sense of what they're saying rather than trying just to pick holes in it, the sense of what they're saying is recognising that you often get people who make mistakes, you often get people who take points that lose, you often get errors of practice or procedure or law, but that's not unreasonable. And in one sense, to get to unreasonable, that is exceptional. The normal case where people just win or lose doesn't justify a finding of unreasonable behaviour. And if you see it in that light, it's not either an exceptional or an unreasonable use of language.
Well, my lord, I accept that. I mean, I don't want to go into the
I
semantics.
don't think it's necessary to your...
No, it's not. But well, you have my submission. Which
Your submission is that they had the wrong mindset because they were looking at, is it exceptional?
Yeah. Yes.
We understand that.
You can only criticise them as a matter of law if they impose an exceptionality test in view of the statutory language. All they're doing is describing an expectation that normally people will behave reasonably. It's an expectation that you will only find unreasonable behaviour less frequently.
Well, yes, I mean, I would agree with that, but I mean, I've made the point that exceptional circumstances, and I appreciate one has to read these decisions of the FTT with a degree of latitude, but nevertheless, I say Judge Cook.
But we don't, yes. I mean, on your main case, we don't get into any of these angels on the end of a pin because your main case is this was so obviously unreasonable that the FTT's decision was a decision that no reasonable tribunal could have reached.
Exactly.
I mean, and that's the bottom line, as it were.
It is, and I'm making this submission really to address the legal point.
Yes.
Which is the question of what the threshold test is.
Yes.
And if one talks of vexatious, abusive behaviour, that is an exceptional circumstance. And what I say is that they appear to be eliding their exceptional circumstance with vexatious behaviour as referred to in Willow Court. But can I just move swiftly on, having tried to make the point? Can I take you, please, to the statutory background, as it were?
But before we embark on this, just for my note, where is this going? I mean, on one view, the test for is something unreasonable is there an explanation which in all the circumstances of the case is reasonable? Explanation for the conduct.
Yeah.
Now, if we're looking at the statutory background, getting into the detail, what do you say the test is? Do you say the test is not asking that question?
Well, it's what I say is that it's certainly not the full test that ought to be applied.
So what is the full test that should be applied? And I'll write it down very slowly so that I know.
Yes.
Because, and I'm sure it's entirely my fault, I'm not entirely clear what it is that you say the test should be beyond what Lord Bingham said the acid test should be.
Yeah. My lords, and I make it clear I don't. My primary case is that, as my lord has indicated, that even if Willow Court is right, then we succeed. But my lord, very simply, what I say is that the test ought to be whether, in all the circumstances, the bringing or the conducting of the proceedings was outside the bounds of ordinary and reasonable behaviour.
Whether in all the circumstances...
The conduct of the proceedings, the bringing or the conducting of the proceedings was outside the bounds of ordinary and reasonable behaviour.
What does ordinary add in this context? Do you need it?
Probably not.
And if you take it out, you're just simply reciting the words of the rule. Slightly rearranged.
Well,
not necessarily in the right order.
Yes, and well, yes, that may be right, but the point I'd make is that I would make is that does the rule, the rhetorical question, does the rule need any further explanation beyond its clear wording?
Well, my initial view is no, it doesn't. And you'll be aware of all the cases that say that the courts have to avoid glossing
Yes.
what the rules say.
Yeah.
That's rather why I piled into, well, in the most gentle possible way, about the use of the word ordinary and.
Yes, or that's a very fair criticism. So, my Lord, can I just explain why I say this, though, that one ought to get away from the acid test as set out in Ryder and Horsfield? Obviously, what the court was considering there were wasted costs, and that's a very different context to the context here. And what Willow Court appears to have done is adopted that test effectively wholesale and therefore tethered the word reasonable to the earlier provision, 13.1a, which is about vexatious and abusive behaviour by legal representatives. Well,
we'll need to look at Willow Court to see that if that is what they are doing.
Yeah, that's the first point. The second point, and a reason why I say the rule doesn't need any further explanation, really, is that if one is looking at applying an acid test, is there a reasonable explanation for this conduct or the bringing of these proceedings? Potentially, at least, that focuses the tribunal's attention on identifying a single reasonable reason. And once you've identified that single reasonable reason, you then conclude that the threshold test is not met.
Well, it's got to be a reasonable explanation in the circumstances of the case.
Yes.
So I think, well, anyway, I have that submission.
And so you can see in this case that what the tribunal has done is to identify what they found to be a reasonable reason. There was going to be a dispute, and therefore it was reasonable to bring proceedings immediately in relation to the fact that there was going to be a dispute. No one could contest that. And it appears, having identified that as a reasonable reason for bringing the application, they then effectively abandon any further consideration.
If you stick to the words of the rule, you ask yourself, is this conduct reasonable? And you have 47 different reasons put up in front of you. And one of them, or 23 of them, or 46 of them may be reasonable. But at the end of it, you just simply ask the question, looking at everything, is this reasonable conduct?
Yes.
No one's going to say, oh, well, I found something which is half reasonable in the depths of the number 46, and therefore that covers the whole case.
But,
unless it's very special.
But no one should do that. But I mean, in this case, I submit that's what the tribunal appears to have done.
Yes, but if the tribunal came forward with some reasoning, which at the end of the day is found to be perverse, that doesn't mean that the legal approach is wrong of asking whether there's a reasonable explanation.
Yeah.
Doesn't mean the test is wrong.
Well, it doesn't mean the test is wrong, but
the difference between the test and the application of the test.
Yes, I mean, and it may be in that respect that the focus on a reasonable reason is unwarranted in this context, and that a more open-textured approach ought to be taken. And of course, I mean, to be clear, in this context, in the context of reasonable or unreasonable behaviour, tribunals and judges are well used to deciding what that is. I mean, take the test for indemnity costs outside the norm. Why is that not an appropriate test in this case?
Because it's not what the rule says, and as soon as you start glossing from a different from a different thing. You'll get exactly the criticism that you're making of translating stuff from wasted costs into unreasonable behaviour.
Yes.
So you're making a very, if I may say so, a very powerful submission that we should stick to the terms of the rule and trust when the devil take the hindmost.
Yes. Well, with that indication, can I move on?
Well, it's not an indication from my lord.
No, I know, but I think
it's a provisional indication from me.
Well, I think I've exhausted what I was going to say on that point, but I do want to address the vexatious, abusive point.
Yeah.
Can I ask you a question? Should the rule not be read without glossing, but at least so that it is capable of including vexatious behaviour? It'd be really odd if that was outside,
Quite.
unreasonable.
Quite.
So if read that way, is there anything wrong with reading across to ride how?
No.
Right.
It's as I say, I think what the tribunal did in Willow Court was effectively, if you read the judgment, to tether those words to the question of unreasonableness, which is different.
Well, shall we look at that?
Yes, if we can. In fact, can I, however, just start with the statutory background, if I may, just briefly. So, if we go to, well, we can start actually in Willow Court. At tab 7 and page 24, one sees the tribunal there set out the background, and I draw the court's attention to paragraph 8. Before that date, 2013, disputes over service charges were demanded by leasehold valuation tribunals, which had only a very limited power to award costs. LVTs could order a party which had acted frivolously, vexatiously, abusively, and disruptively, or otherwise unreasonably in connection with the proceedings before it, to pay up to £500 in costs. So, my lord, those words, frivolously down to in connection with the proceedings, that's a direct quote from paragraph 10.4 of Schedule 12, which unfortunately I haven't included in the bundle, but I can supply copies of. And so the point is that in 2007, when Section 29 was introduced, Section 29 of the Act, a different approach was taken by Parliament, and that's apparent if we can go to page 4 of the authorities bundle, tab 1. The 2007 Act then says the costs of an identical to all...
Sorry, which tab?
Sorry, this is tab 1, page
Tab
4
1.
of the authorities bundle.
Yeah.
Section 29.1, the costs of an incidental to all proceedings shall be in the discretion of the tribunal in which the proceedings take place.
Yeah.
And then the key sub-rule, subparagraph 3, subsections 1 and 2 have effect subject to tribunal procedure rules.
Yeah.
And so that's where the 2013 rules are introduced. And so what Parliament was doing there was quite clearly, in effectively abolishing the frivolous, vexatious, or otherwise unreasonable test, and suggesting that, subject to tribunal rules, tribunals would have the same discretion as a court would ordinarily have in ordinary proceedings. Then, when the rule is introduced, we see page 14, tab 5 of the authorities bundle, that a limited cost shifting jurisdiction is introduced for our tribunal. The tribunal may make an order only under section 29(4), that's the wasted cost jurisdiction, if a person has acted unreasonably in bringing, defending or conducting the proceedings. So by dividing those two sections and bearing in mind the rule that was being abolished, Parliament is certainly giving a much more open opportunity for the award of costs, rebalancing the position, as it were, between litigants by using that open textured word unreasonably and clearly and apparently not tethering it to the wasted cost jurisdiction, which simply imports section 51, 6 and 7 of the Supreme Court Act, the same test as we apply in these courts. In other words, section 29, 4 and 5, which I don't think I really took you to, but I think you may have already seen them, they deal with wasted costs and effectively incorporate the provisions of section 51, 6 and 7. In other words, improper, unreasonable or negligent acts or omissions. But Parliament's drawing a clear distinction, apparently, by not eliding the two rules in 13(1)A and B. So I submit that tends to suggest that Parliament was not intending to tether Rule 13(1)B to the threshold test for wasted costs as incorporated in 13(1)A. So whereas under the old provisions of the 2002 Act, the words or otherwise unreasonably would have taken their meaning from the previous words vexatiously, abusively, Euston generous construction would suggest other or otherwise unreasonably is certainly to be tied to those criterion. Parliament hasn't done that here. It's used a much more open word.
Well, it's used one of the words from the wasted costs order.
It does take one of the words from...
It takes one of the words unreasonable.
Yeah.
What does that mean? See Lord Bingham.
Yes, in the context of wasted costs, which is very different to...
But that's really what my earlier question went to. Are you saying that the question was the conduct in all the circumstances of this case reasonable? Do you say that's not the question if you're not dealing with wasted costs?
No.
I mean, that's the point. We all understand that was a case about wasted costs, but in the paragraph where he explains what reasonable means, you could say that's a self-contained paragraph concerned with what reasonable means.
Yes, although he goes on to say that the court were asked to give separate meanings to each of those three words, negligent, improper, unreasonable. Yeah. And the court refused to do so because you've got to treat it as a compendious phrase.
Of course, but that's why, is there actually a difference? And I think you're saying no. You accept that ultimately becomes the question. The acid test.
Yeah, I mean, I'm accepting that a definition of unreasonable is as set out in Lord Bingham's test. But I say the problem is that if you look at...
Don't spend too much time looking at wasted costs.
Exactly.
But that's okay. I mean, well, I can't at the moment think of any sphere of the law where unreasonable doesn't mean lacking a reasonable basis. And that's it, isn't it? And it would include vexatious behaviour.
Yeah.
It will include, or if I say always, someone will find some clever exception. But basically, behaviour that is vexatious or probably frivolous or whatever is at least unlikely to have a reasonable justification or explanation.
Yes.
End of.
Yeah. Yes,
But then I don't quite understand why you're so reticent, apart from saying correctly, wasted costs and Rule 13B applications are different. So don't get too hung up on anything specific to wasted costs. But provided we don't do that.
Yes. Yes, I'd accept that. I mean, and the problem is that in Willow Court, I say the tribunal does definitely effectively tie unreasonableness to vexatious.
And that's why I've been nudging you to come to Willow Court, because that you come back to that submission, you come back to it for a third time.
But
we understand that. Can we see that?
Well, it was, yes, and
We have the statutory background. We understand that it used to be frivolous, vexatious, what have you. It's now wider than that.
Yep.
So we have that point. So take us to Willow Court and where you say that elision is made.
Yes. Paragraph, page 21, tab 7. This is the head note. H6, the Court of Appeal guidance on what constitutes unreasonable conduct in the context of wasted cost applies in the FTT proceedings for the purposes of Rule 13.1b rather than having a wider interpretation. Applications under Rule 13.1b, this is H8, should not be regarded as routine, should not be abused to discourage access, and should not be allowed to become major disputes in their own right.
Where are you reading from?
Sorry, that was the head note, H8, middle of page 21.
H8.
H8.
Yeah.
And then over to 27, wasted costs. None of the decisions included the wasted costs order, but it's relevant for us to begin by considering the power, because all of the submissions on the power were those cases where a party has behaved unreasonably or referred to in the leading judgment. Over the page, then the tribunal deal with Ryder and Horsfield, and point out that in 21, having quoted from the key part of Lord Bingham's judgment, the whole of the discussion is couched in terms of conduct of professional lawyers concerned with construction of a tripartite expression. That context has to be borne in mind when considering the different subject matter and language of 13.1b. And then the language, 22, the language and approach, halfway, third of the way down, of 13.1b are clear and sufficiently illuminated by the decision in Ryder and Horsfield. And then 23, there was a divergence of view amongst counsel on the relevance to these appeals of the guidance given in Horsfield on what amounts to unreasonable behaviour. It was pointed out that in 13.1b the word acted unreasonably are not constrained by association with improper or negligent conduct. It was submitted that unreasonableness should not be interpreted as encompassing only behaviour which is capable of being described as vexatious, abusive or frivolous. We were urged by Mr. Allison to adopt a wider interpretation. And over the page, it was wrong, he submitted, Mr. Allison, to approach the jurisdiction to rule costs for unreasonable behaviour on the basis that such order should be exceptional. We do not accept these submissions. So the court, the tribunal there seemed to be rejecting the submission that the earlier submission, all of the submissions, including that unreasonableness should not be interpreted as encompassing only behaviour, which is capable of being described as vexatious, abusive or frivolous.
Is that what the submission is founded on? What you've just read from the beginning of 24? We do not accept these submissions. Because if you read on in 24, it reads rather differently through to the end of the paragraph.
surely, as my Lord says, the test that the Willow Court is applying is the last set out in the last 4 lines of 24. And if there was any doubt about that, they repeat it in paragraph 32. When considering objectively whether a party has acted reasonably or not, the question is whether a reasonable person, in the circumstances in which the party in question found themselves, would have acted in the way the party acted.
Yeah.
That's the Willow Court test.
Yes.
And by the way, it does include, though it doesn't have to, vexatiousness, impropriety.
Yeah.
You wouldn't want to lose those. You wouldn't want to exclude that from the concept of unreasonableness.
No.
You don't want to tie it to those concepts, but you don't want to exclude it either.
But it does. It certainly, I think, has been interpreted as a rejection of the submission made that I read out earlier.
Let's just concentrate on Willow Court, because you said that restricted.
Yeah.
Come on to how it's been interpreted.
Yeah.
My lords have pointed out that in 24, leaving aside the first sentence, the court seems to be quite clear that unreasonable conduct includes conduct which is vexatious, and then goes on to ask Lord Bingham's specific questions. So wouldn't appear to be restricting it in the way you've submitted. As to that first sentence, we do not accept these submissions, that then turns on a grammatical parsing of the previous paragraph, because Mr. Allison gets mentioned in the "we were urged" in particular by Mr. Allison 6 lines down, and then repeated again, he submitted, and then it's "we do not accept these submissions." It was submitted that unreasonableness should not be interpreted as encompassing only behaviour, which is also capable of being described as vexatious, abusive or frivolous. That submission is not linked to Mr. Allison. It might have been making it, but it isn't linked to him. And it's clear that they do accept that submission because of what's later said in paragraph 24.
Yes.
So if your submission is based solely on the words "we do not accept these submissions," I think that places rather too great a weight on what they're actually doing by reference to paragraph 23.
Well, if that's the way this court interprets it, then that's helpful a clarification.
I think from where I'm sitting, you've had at least 3 indications, one from each of us, that we're not at present inclined to say that unreasonable behaviour has to involve a finding of vexatiousness or harassment.
Yeah.
It's it's simply the word of the rule.
Yeah.
And vexatious and even your frivolous behaviour may be unreasonable.
Yeah.
But that's not what the rule says. The rule is simpler.
Exactly. And
Would
in my
you be happy with that? I mean,
yes, absolutely.
If I've correctly reflected what I think my lords are saying,
yeah,
you're content with that?
Yes, indeed.
I mean, after all, with the Court of Appeal, we can define it as we think right.
Yeah, indeed. And implicitly, my lords are accepting that Mr. Allison was right in pointing out that the words "acted unreasonably" are not constrained by association with improper or negligent conduct. And that
speaking entirely for myself, that's where I'm at the moment.
Yeah. Well, I'm very grateful for that.
Because otherwise it would be a gloss on the words. It's as simple as that.
Yeah. Absolutely. And I mean, can I just take you
on this happy note? Would that also accord with what the Court of Appeal decided in the small claims context in Dammerman?
Yeah. Yeah. Absolutely. And just to make the point that it would be very helpful to have this clarification, can I just take you to one relatively recent...
You're going to take us to asset hold?
Yes.
And subject to hearing Mr. Bates, I think the sentence in asset hold is wrong as a matter of law.
Thank you.
Because their unreasonable is said to equal vexatious.
Yeah, exactly. That's
and that's an impermissible gloss on the words. It's contrary to, I think, what the court said in Willow Court. And at the moment, I think it's wrong.
Thank you.
I'm very happy to be persuaded by Mr. Bates, but you don't need to make that point further.
Thank you.
Because it follows from what we've said, both about Willow Court, but also, as my lord has said, about Dammerman.
Thank you. Then I don't need to take you to either of those cases. My lords, I think you have my submissions. And going back to where we started, if you're with me that this was an exercise of discretion outside of the generous ambit given to a first instance tribunal, then the appeal must be allowed anyway. Equally, the ignoring of those, or apparent overlooking of those key features of their earlier decision, particularly at page 77, means that this court should exercise the discretion afresh.
There is one point I wanted to ask you about that. Willow Court, paragraph 28, makes clear that the first stage in the analysis, namely, is it unreasonable, is not an exercise of discretion.
Yeah.
That it's a question of objective standard of conduct on the facts of the case. So I mean, clearly, the First Tier Tribunal, when they came to their conclusion in relation to that, that was an evaluative judgment. You've made your submissions about that. We'll have to consider that because obviously this court pays proper respect to evaluative judgments, but it's not an exercise of discretion. It's not, in fact, clear to me what difference that makes. But I'm speaking for myself. I think the court was right in Willow Court to say that that first stage is not an exercise of discretion.
Yeah. I mean, if you have to split it up into 3 stages, as Willow Court did, which I have to say I don't think you do have to, then that part of the test must be evaluative, not discretionary. I mean, in fact, since Willow Court, some of the tribunal cases have said, well, even where some of the upper tribunal cases have said, even where the FTT don't go through the 3-stage test, it doesn't matter provided they've made a proper decision.
Well, I read this as being guidance.
Yeah.
And I thought that it was probably quite useful guidance, but it was just that specific point because you referred to about an exercise of discretion. But the first stage, and that's what we're arguing about in this case, the unreasonableness is a finding, objective finding of fact.
Indeed, yeah. I have no quarrel with that at all. My lords, I think you have my submissions, unless there's anything further I can assist with.
Let's just make a note. No, thank you very much, Mr. Hutchings. Yes, Mr. Bates.
My lords, there are 3 parts to my submissions, and I can take you through them hopefully fairly quickly. The first, I want to draw out some parts of the FTT's judgment in particular that we haven't looked at yet. Secondly, though I suspect, having watched the last 20 minutes, there's now a large degree of overlap on the second issue, I'll address briefly what is the test under Rule 13. And just to quickly flag it up now, we'll be saying the test is the rule, Willow Court is helpful guidance. There's nothing more than that. And then finally, drawing this together to respond to the criticisms that are made of the First Tier Tribunal's decision and why we say ultimately they came to a permissible conclusion. But before I do that, just 2 points that have come up in exchange with my learned friend. One of my lords, I forget who I'm afraid, asked whether there were any rules in the FTT about providing your service charge demands at the very beginning of your case. My memory is that the practice direction governing service charge applications says you only have to provide the lease at the beginning.
You only have to
provide the lease of the property with the application form. The reality is I suspect everyone's already realised, is that the tribunal grabs these cases, case manages them fairly actively. There will generally be directions for proper disclosure to evidence your claims, etc. And for what it's worth, I agree with my learned friend. In the bigger, higher value cases, whilst it's permissible to start a claim by filling in the application form with no equivalent particulars, in the bigger cases, people submit fully pleaded out claims, attaching evidence, etc.
My understanding from reading, because as you will know, this is not a specialist field for me, or it's not a field where I am a specialist under any circumstances, is that if you are about to make a demand for service charges, and particularly if you think they might be contentious, then it is at least good practice, and I would expect common practice, to provide with the demand some backup documents, the extent of whatever backup documents being for you to decide whatever you think is going to persuade the leaseholders.
I wouldn't disagree with that at all.
But I don't think
transparency is very much a virtue in these proceedings.
That's a very neat phrase.
Whether it was achieved here is another matter, but as a matter of general principle, I would agree. The second matter that arose in discussion with my learned friend is this mammoth judgment that was handed down on Friday. My lord talks about areas where he's not an expert. My knowledge of collective investment funds could fill the back of a postage stamp. I struggle for my part to understand how that can be relevant to the question on the appeal, because the findings of Mr. Justice Foxton can't tell us whether this tribunal was right in 2001, 2002. I also query, picking up I think on my lord's point, whether it could be relevant at all, whether you're against me on the appeal and you remit, or you want to redecide the question yourself, because you're grappling with how we conducted these proceedings. That's what Rule 13 says. And subject to seeing the judgment and seeing the particular paragraphs relied upon, I confess I'd be surprised if they had anything of relevance to these proceedings. But it may be that that's best parked for later on, once we know your decision on the substantive questions on the appeal. So turning then
well,
to...
just on that,
my lord, yes.
I think that the modus operandi that we agreed was that we'd be provided with a copy of the judgment noted up with any paragraphs, the paragraphs that are said potentially to be relevant to this. Would you object if we considered that de bene esse, as they say, and we have your submissions as to why you say it's not relevant? I mean, that might be a neater way of doing it, particularly as your submissions may all be done by the short adjournment, and I don't want to prolong it if I don't need to.
Quite. I have one eye on that as well. I don't think, regrettably, I can accede to that. I'm not instructed for any of the respondents in that appeal.
No.
Nor are my solicitors.
No.
I have no idea what, if any, steps are planned in relation to an appeal. And I'm very, very cautious about standing here representing a company and accepting a position that it may not agree with and may be advised against in other proceedings.
It may not be necessary anyway.
It may not be necessary anyway. But regrettably, I can't agree to that, I'm afraid. If the court does it, then so be it. But you'll appreciate I don't feel I can agree to that.
Yeah.
Turning then to the FTT's decision in particular, can we start with the underlying service charge decision? Because I respectfully say there's rather more that explains the cost decision in there than we went through earlier this morning. One of the things the Tribunal says at paragraph 66 of its costs decision is that they always thought litigation was going to be inevitable anyway. And we can see the reason they thought that. If in the appeal bundle you go to page 76, at paragraph 92, because the problem with this case wasn't just the inadequacy of the demands. The entire structure, physically and legally, of this development is a nightmare. So paragraph 92, they note the leases are unsatisfactory, they don't appear to reflect the fact that it's a holiday park with holiday units, with holiday accommodation, there are on the facilities that should be there. The leases fail to provide a proper structure for the provision of services and the collection of costs are the same.
Yeah.
We then see at 93 and 94...
So what's the point of that?
So one of the points the tribunal is going to make in costs is that they thought litigation was always going to be inevitable.
Litigation, yes, but not a service charge demand in circumstances where the leases are hopeless.
Well,
Service charge demand assumes that the leases are valid documents.
well, but of course the demand has to relate to the mechanism in the lease. So the service
Yes,
charge...
so if the lease is hopeless, you need to get that sorted out first.
You do, and we'll see later on, the tribunal then gives us examples of where the lease is hopeless, to put it colloquially, because it doesn't do the things you'd expect it to do.
Yeah.
We'll see in a moment that one of the things Mr. Gubbe, on behalf of my company, was saying was, well, leases normally allow me to do this, and the tribunal says, but there's no clause that lets you do this, there's no clause that lets you do that. So I just draw attention to that, because it's not as simple as saying there was a service charge demand, it couldn't be backed up. We're operating against a backdrop of a fundamentally flawed development. And you see that in the next paragraphs as well.
So if it's a fundamentally flawed development, why was there a service charge demand for 2.4 million?
Well, as Mr. Gubbe explained...
No, my question is to your clients. If they knew that the leases were far from satisfactory, why was there a service charge demand at all?
Because as the tribunal judgment explains, services had been provided, things were needed, and there's plainly a dispute about what the lease entitled you to recover.
The tribunal couldn't sort out the leases, and there was ongoing litigation to do that.
Well, that was to rescind the leases.
Yes.
The tribunal has to interpret the lease. So the usual way you approach a service charge dispute, forgive me for teaching everyone such professional legs, start with the lease. What does it allow you to charge for? There will be somewhere in one of the schedules a list of chargeable things.
The swimming pool was an example.
Swimming pool is an example. And you frequently have litigation about, well, what does paragraph Y of Schedule X mean? Is management apt to cover the surveyor, for example? The next thing you ask yourself is the demand in accordance with the lease? Because there'll be an apportionment mechanism.
Yeah.
And we'll see here, that's a problem as well, because the parties can't even agree how many contributing units there are at this development. Then you move to statutory questions. Is it reasonable in the statutory sense? Has there been the necessary pre-consultation, as my lord alluded to? And all of these, what the tribunal is doing in this decision, in my submission, is drawing attention to the fact that there are so many structural problems at this development that it is a reasonable thing for my client company to have done, to have issued litigation to get the tribunal's determination.
Well, where do we find that?
Well, can I take you through that in turn?
Yeah, because that's the key thing.
I agree. But 92 I start with. The tribunal notes the failure of the leases to reflect what's happening on the ground. I do ask you to look at 93 through to 96, because 93, Mr. Gubbe, on behalf of my client, says that he reads the leases as requiring service charges to be split equally between all units. Mr. Verdun, by contrast, acting for the leaseholders, says no, it's apportioned equally between the residential units. At 95, and this is a point against me, I accept, the budgets didn't actually demand it between all the units. So even though, having said we thought you split it equally, we hadn't done that. But 96 is the critical one. The tribunal can't actually be sure how many contributing units actually exist on the grounds. And then they tell you in 96...
So a claim was made in circumstances where the claimant couldn't provide information as to how many units there were on the ground.
And the logically prior question, the more important prior question, which was, what does the lease require you to split them between? Is it all units or is it residential?
Well, question mark whether that's a prior question, but these might be regarded as fairly fundamental building blocks. If Janet and John have a service charge claim, and if you don't get beyond page 1 of that, then it might be said this was a wholly unreasonable claim.
So save that, we then get 97. This is the benefit that everyone obtains as a result of the matters set out in 93 through to 96. The tribunal then tells everyone how you have to apportion these costs. They have to be apportioned across all units and all for the same amount. That's a practical benefit you obtain from this litigation because they've now made a decision about what these leases mean and how demands must be calculated.
And is that binding? Given the absence of documentation that they had?
But it's binding as to what the meaning of the lease is, because of course what the lease governs the apportionment, and that tells you how it shall be apportioned. They don't purport to find how many units there are, and I accept the point you put back. That's a fairly significant difficulty. But it's not as simple as there being no proper basis for these service charge demands. What my client company was doing was grappling with how do you take forward the management of a fundamentally flawed development where we can't even agree about the most basic questions, i.e. how many physical units exist.
But where you end up on that particular issue is insufficient material before the tribunal to enable them to answer that question.
Well, we get an answer to one of the two questions.
No, but that particular question.
Yes. So we get an answer to how does the lease work, not what is the number over which the cost.
You also get a finding that even if you're wrong, which is in 99, even if they're wrong on the method of appointment, their finding is that the budget is not reasonable in its entirety and not payable.
Agreed. And that's because
that's pretty fundamental too.
Well, I can't shy away from this. We didn't lead any evidence to justify our conclusion, and the finding is we couldn't have justified it. I can't hide that. What I'm doing is drawing attention to what you do get that's useful for everyone from this development. And what you also get that's useful to everyone are the findings at 104 onwards, where they go through various heads of what were claimed service charge expenditure and say yay or nay whether the lease allows for this. Now again, this is common service charge litigation. The tribunal telling you, does the lease allow you to charge for the cleaners, the gardener, etc. So they set out at 104 through to 106. They accept logic of Mr. Govey's position that generally you'd expect people to pay for the things they benefit from, but they say, well, the lease doesn't provide for it. 107 and 108, in very shorthand, they're making one of the most common landlord and tenant determinations going, improvements fall outside, this is a repairing lease, not an improving lease. 109, directors and officers insurance isn't a recoverable service charge item. 110, they appear to accept that in principle a management fee is chargeable, and they appear to accept that in principle it probably will be higher than that charged by managing agents for normal residential blocks. But on the facts of the case, they can't award anything. It seems to me as well at 111 to 113, they seem to accept that in principle management fees and staff costs could be recovered, but we fall down on the facts of the case. So all of that, all of those disputes, in my submission, the tribunal, when it comes to its cost decision, it's got in mind all of those factors. And when we come to costs, and I'll take you there in a moment, the tribunal is directing itself by reference to the fact that this is such a difficult development that litigation was inevitable, and that's why it was reasonable to bring the proceedings.
Why it could have been reasonable to bring proceedings.
Well,
If they had been founded on a genuine belief that the costs being advanced were real.
well, the tribunal finds that they're not unreasonable. I appreciate the challenges, they shouldn't have found that. But if I limit myself to what the tribunal found for a moment, and then I'll address the criticisms as to why they shouldn't have found that. Before we leave the main decision, the last sentence of paragraph 115, I draw to your attention as well. Because having criticised in the opening sentence of 115, noted how unusual it is to determine that nothing is payable, they then say, we're nearly at the year end, there'll be actual accounts and expenditure, which is supported by evidence which the respondents can consider. So what they're envisaging is reconciliation in light of their judgment.
No, aren't they simply contemplating that a properly based charge will be advanced in the future, as has not happened so far?
Well, respectfully, I say they are envisaging benefits from their judgment because, of course, they've gone through and told us items that must not appear in the service charges. That will need to be dealt with in the reconciliation. Turning to parts of the costs decision then.
I mean, at 104, they start this section of their decision with the words, whilst we do not need to.
Correct.
It looks as if they're trying to be helpful,
Correct.
given the very sorry state of affairs that these proceedings have got to. But picking up my Lord's question, it does make you rather wonder whether that's a binding determination.
Leaving aside the intricacies of issue estoppel and NatWest and Arnold, I suspect it wouldn't be controversial to say that at a purely practical level, a budget that was recalculated excluding all of the things that they found were not chargeable is likely to find more favour with the FTT than one that ignores that decision, says, well, technically I can frame all this as overtime. Therefore, I shall reincorporate all these charges.
The swimming pool might not be included anymore.
Quite. And also, not just that, but of course the indication as to what they'd expect the reasonable level of fee to be for staff and for management services. Turning to the costs decision, I want to spend slightly more time on this.
Could I ask a question?
My Lord, yes.
Going back to the statute under which the application is made, it's tab 3 of the authority.
It's 27A, yes.
27A, liability to pay service charge, jurisdiction. And we're told what an application can be made to a tribunal for a determination whether a service charge is payable and so on. And into subsection 3, for a determination whether if costs were incurred for services repairs. In other words, if you've got an interpretational dispute about what you can and cannot do under a lease, it seems to helpfully envisage you can have an application which asks for the lease to be interpreted, even if you don't have a service charge demand.
I agree. 27A3 is effectively declaratory relief.
So that's what I thought. So you can do that rather than putting in some cases perhaps a bogus service charge demand.
You can do either. So the
particularly one without computation.
I certainly agree you could go to the tribunal, and I'll go further. It's relatively.
But again, your ability to do that would perhaps depend upon prior dialogue, where you identify what the issues are with the lessees, to know what people are squabbling about.
Well, we do know from part of this decision, part of what they were squabbling about. They couldn't they couldn't agree the apportionment method. That's quite important.
Well, that's an interpretational point.
Yes, and that so you could have taken a freestanding 27A3 case and just gone to the tribunal and said, look, we can't agree.
And the costs would have been related just to that point of interpretation.
Yes.
Any others like it.
So I agree, that would have been possible. And you're quite right, 27A3 lets you go before and after the event. 27A3 is effectively declaratory.
And indeed, where you've got a very big area of land and quite complex, before you go through the computational exercise, which could be quite costly, there might be an advantage in getting interpretational points dealt with beforehand.
I wouldn't disagree. It's relatively common, particularly for bigger disputes, bigger cases. my own friend and I have 2 days in December in the Upper Tribunal about several £1 million worth of cladding, which is a 27A3 dispute. Yes, that's a very good example of the kind of thing you can use 27A3 for. But then just turning to the costs decision, starting behind tab 9 at page 88, we noted at paragraph 3 that my client can respond, and Mr. Gubbay was now no longer representing my client, but was looking to his own interests expressly. Can we just look at how the tribunal understood the case to be put? Because that starts at paragraph 10 on page 90. So paragraph 10, the reference there is to the first reason why it said that costs can be awarded against my client is that we hadn't resisted the application. Then paragraph 11 is the second reason why my client should pay costs, which is the conduct of the application, and reference is made to the aborted withdrawal application. And he suggests we're a party of straw. Paragraph 12 is irrelevant to this appeal because that's about disallowing contractual rights to costs under leases. And then we turn to paragraph 13, and by now the tribunal understands that it's dealing here with freestanding criticisms against Mr. Gubbay as a representative. And the criticisms at paragraph 13 is that Mr. Gubbay didn't evidence claims he made about his companies. Paragraph 14, there's a doubt about the authenticity of a tender report. Paragraph 15, Mr. Gubbay had been off on a frolic of his own. Paragraph 16, Mr. Gubbay runs a multi-billion pound portfolio. He's protecting his own interests. Paragraph 17 doesn't seem to me to take us any further. Paragraph 18, Mr. Gubbay had said that the previous cost orders had been paid, but they hadn't been. Paragraph 19, budget set by Gubbay with no genuine belief in its figures. That, of course, is the finding that the tribunal made previously. The next sentence is the submission. The purpose was to be vexatious and to harass the leaseholders by bringing pressure upon them. Because the finding, there's no finding to that effect in the substantive decision. Indeed, to the contrary, the finding the tribunal eventually makes is that this was an attempt to bring people to the table. Misguided or not, that's what it was. So paragraph 19, the first half is finding, second half is submission. Paragraph 20 then is effectively saying the litigation is being conducted in a shambolic manner. Paragraph 21 then comes back to the withdrawal application. And then the tribunal goes on to hear submissions about quantum.
Yeah.
So we then go to page 94.
So what do we get from all of that?
So we get from that the distinction that's drawn in the way the tribunal understood the case between the criticisms of my client and the criticism of Mr. Gubbay. Because the two specific criticisms that were made of my client were paragraph 10 and 11. Because one of the points that was put back to my own friend this morning is there isn't a lot of discussion of my client itself in this judgment. That's because only two distinct criticisms were made.
Well, those are the 2 points that are referred to in the judgment. But they go on to deal with whether or not the conduct was unreasonable. So they clearly had that in mind. That is, you are quite right, that's not set out in 10 and 11. But they clearly appreciated that that was a point that was being made by the appellants.
I appreciate this and I accept this, and I also, it could be said against me, and I'm sure it would be. I have to accept some responsibility for Mr. Gubbay because he was plainly acting as my agent with various different hats on at different stages.
Well, I'm not sure it's a question of accepting responsibility for. I think all we're interested in, because the appeal just concerns the respondent company.
Quite.
And so what we're interested in is the decision on costs involving the respondent company and the 3 lines or whatever it is that says not unreasonable.
So then we see, so let me then take you through the paragraphs of the decision that I rely upon in particular. You start at 48. The unusual nature of the case is identified, and the tribunal then makes the inaccurate but understandable error that all those who took part accept that a fraud may have been perpetrated. My client doesn't accept that, of course, or didn't accept that before the FTT.
No, well, that's all part of the muddle that runs through the cost determination like a stick of rock, that they didn't properly address the difference between the application against the applicant and the application against Mr. Gube and his company.
But we do have then at 53 and 54 the 2 specific findings of unreasonable behaviour against my client. 53 is the aborted withdrawal application, and towards the end of that paragraph, I think it's the last sentence, judge had already indicated there was prima facie unreasonable conduct, and made clear that he'd deal with the cost consequences after substantive hearing. We know he's going to go on to make that cost order. And then at 54, my client's failure to comply with the directions of preparing the bundle, the respondent's solicitor's costs of remedying that default are covered by Rule 13, and although they don't say so, they must obviously have found, therefore, it was unreasonable conduct. Then you come to 66 in my submission. And this paragraph is why I started where I did, by looking at 92 in the first decision and the leases. Because they say in the second sentence, we suggest it's plain the demands were going to be subject to challenge. We make reference in our original decision to what we consider to be the unsatisfactory nature of the leases. So they always thought there was going to be litigation. They think the leases are so unsatisfactory that that makes that inevitable.
Well, then this is the critical sentence. This is a classic situation where a management company may well apply to the tribunal to seek clarity. So you'd expect the application to say, these are the points which are unclear, this is what we need clarity on. But did that happen in this case?
Well, we don't have the pleadings before, and no one shaped their argument by reference to that. But we do know
this was a claim for a service charge, which was hopeless and unsupported by a single shred of proper evidence. To say this litigation was always envisaged simply can't be right. Properly constituted litigation may well have been envisaged. That was not this.
I come back to the words the tribunal used. We would suggest it's plain the demands were going to be subject to challenge, and the reason they give for that is the unsatisfactory nature of the leases.
Well, that's the next sentence.
No, speaking entirely for myself, what really matters in this case is this was launched with no genuine belief in the validity of the figures. It could be wrong, that's fine. But to launch proceedings such as these with no reasonable belief or no genuine belief in the validity of the figures for which you are ostensibly contending seems, to me at least, to put this in a different category.
But then respectfully, my lord, the answer to that is paragraph 69. Because there the tribunal grapples with, well, why were these claims issued? And they tell us, they accept that Mr. Gove believed in his own way he was doing the best for everyone. Well, whether his view is misguided or not is not a matter we need to determine.
Wrong. That's wrong though, isn't it? Because he did need to determine it to work out whether it was objectively reasonable. Mr. Gubbe believed in his own way he was doing his best. Well, that's the subjective position. But whether conduct is reasonable or unreasonable is an objective fact.
But when you take that sentence in 69, Mr. Gubbe believed in his own way that he was doing the best for everyone. You read that in light of the Tribunal's view about the defective nature of the leases, the guidance the Tribunal has given about how the leases should operate in terms of division of cost, in terms of permissible chargeable items. The Tribunal has taken the view that this litigation has achieved a degree of clarity. And if it comes to that view, whatever the Willow court test, then it's entitled to conclude that it's not unreasonable so as to invoke the Rule 13 power.
Forgive me for interrupting yet again. We know that the overall sum claimed was about 2.4 million. Just in very, very rough terms, what was that per person or per unit? Was it about 100,000?
I don't know is the honest answer, and I wouldn't want to speculate. At the risk of a slightly cheeky answer, given the Tribunal has told us that we have to divide it equally, and the Tribunal doesn't tell us how many units there are.
But if, on an assumption, there were 240, I think my Lord is right.
It's not going to be a million miles away from that figure. It's not. There will be edge decisions with commercial units, etc. And you may have picked up there's been disputes as well about whether certain units were occupiable and therefore they could be charged or not.
Are you asserting that in bringing the application, your client was not contending for a finding that 2.4 million was payable?
In bringing the application, what it must have been asserting that it had a right to some or all of that money.
All of it?
Well, pleadings aren't before us, so I don't know if anything was said, for example, about all such other reasonable sum as the Tribunal may determine. But respectfully, my Lord, that's not the question on the appeal. The question on the appeal is, having heard 2 days' worth of evidence and a day's worth of submissions on costs, having drawn attention to what they regarded as the highly unusual features of his claim, was it still nonetheless open to the Tribunal to take the view that this wasn't unreasonable behaviour? In my respectful submission, not only was that open to them, their conclusion is fortified and the difficulty on appeal magnified by the fact that they did find 2 specific items of unreasonable behaviour. Because they make costs award against us for our failure to comply with directions on the bundle, and they make costs awards against us in respect of the aborted application to withdraw.
Yeah, no, I get that. Although it is fair to say those were discrete applications that were made. You've shown us the paragraphs where those were separately made. So I take the generality of that, but it is a fair point to say, well, yes, those were specific applications were made, and those were both successful. It was the general application that wasn't.
That's quite right, but the point I'm seeking to make is a slightly more general one. It's the point we all know, and the point very fairly put to my learned friend. The starting point is the Tribunal is entitled to make its decisions, even decisions that this court regards as generous. The ground for interference is only if no properly directed tribunal could come to that question, or it asked itself the wrong question in law.
Yeah.
On the first of those, no properly directed tribunal, I've drawn attention to what I say are the other factors that went into the Tribunal's thought process, which my learned friend didn't take you to and which this court didn't put to him. I've drawn attention to the general point, the advantage of hearing evidence over 2 days, etc. Can I just draw attention to a third point, which emerged from Judge Cook's decision in the Upper Tribunal? Behind tab 4, at page 44, paragraph 56, Judge Cook was also taken through the transcript of the hearing, and of course you haven't been. Now, it's not a jury point, it's making the well-known point about the dangers of island hopping on appeals. And back to merge into issue 2 and what's the test.
That is a jury point. We haven't island hopped. We've been through 117 paragraphs or whatever it was of the original decision. If you have a point to make on the transcript, then that should have been part of the bundles.
No. My point, my lord, is I'm perfectly content with the decisions of the FTT and Upper Tribunal. I say they got it spot on.
Yeah. We can't take into account a transcript we haven't seen, so we have to look simply at the material with which we've been provided.
But we also respectfully bear in mind, and we're about to move into issue 2, and what's the test? If the test is a multifactorial assessment of all relevant circumstances, which I think we're all agreeing it probably is.
If you're going to make this submission, you've got to take us to the relevant bits of the transcript.
Well, my lord,
otherwise it's cheating. You're saying you can't decide against me because there's a bit in the appeal by reference to a document you haven't got.
Let me try it another way then, because I'm not trying to cheat. Let me try it another way. Judge Cook has already carried out the usual review of the first instance appellate court. And my point in my submission is she was in a rather better position because the criticisms that are made of the tribunal could or should have been supported by transcript evidence.
All right, well, my answer is this is all under the heading Mr. Gubbay's conduct and a conflict of interest. And it's to do with him believing he's doing the best for everyone. As I say, all of these decisions, the Upper Tribunal not excluded, are far too muddled on what they are dealing with. None of them address the only point we have to address, which is the potential liability of the respondent to this appeal.
Well, then in that case, my lord, then I've drawn out what I want to do. Sorry, my lord.
As far as Judge Cook is concerned, is the essence of her reasoning for not interfering with the FTT's decision in paragraph 48, page 42?
Yes, that's the paragraph I marked as well. Yes.
Yes. Well, for my part, I couldn't see that it added anything to what was in the FTT.
No, and that's why I wanted to focus on
I can't see how the transcript helps.
Let me then move to what's the test. And respectfully, we say, I think as a friend this morning, that the test is in the rule. Is it unreasonable behaviour? To the extent that first-tier tribunals seek guidance about identifying that, Willow Court is perfectly acceptable guidance. And that's all Willow Court is purporting to do. I'll deal with it very briefly. In the authorities bundle behind tab 7, just draw attention to the last sentence of paragraph 22 on page 28 of the authorities bundle.
So page?
Page 28 of the authorities bundle.
Thank you.
Paragraph 22.
Yeah.
The Upper Tribunal reviews, in particular, the approach that the immigration chamber has taken. It's the last sentence. The tribunal, i.e. the immigration chamber, repeatedly emphasises the fact-sensitive nature of the inquiry in each case. And then we see...
In every case?
In every case, yes.
In every case?
In every case, yes.
And it's not just the tribunal there, it's in every case that is concerned with costs.
Right.
It's a fact-sensitive exercise.
Yes, that is the unifying theme through all of the decisions, whether they are on their own facts or trying to establish general guidance. The unifying theme is it's fact-sensitive.
Yeah.
And you see that in the first sentence of paragraph 24. The assessment is a value judgment. First sentence of paragraph 24. We see no reason to depart from right hall, despite the living conduct. Unreasonable conduct includes conduct which is vexatious. The test may be expressed in different ways, and they come back to Sir Thomas Bingham's test. It's what English lawyers call the elephant test. You know it when you see it. It's not always that easy to describe. American lawyers, I'm told, call it the pornography test. They make clear at 25 you can't give general guidance, you can't prejudge certain types of behaviour as reasonable or unreasonable. They draw attention, importantly, given like some of the criticisms that were made of my client, in 26, the last sentence. Case management powers are, of course, the way of dealing with obstruction, pettiness and gamesmanship. So when parties are concerned about the lack of disclosure, it's case management powers that are the appropriate route, rather than going straight to costs. And
You don't go straight to costs. You only go to costs at the end of the hearing.
But as a remedy or as a sanction, would be my point there. And finally, just to bring home why we say this, that it's helpful guidance, we've drawn attention to the Dammerman case, which is behind tab 9, that my Lord Holgate picked up already. This court, dealing with a power to award costs against unreasonable behaviour in a small claims track, at page 129, has indicated that these are highly fact-sensitive decisions.
Where are you?
Authorities, tab 9, page 129.
Thank you.
Paragraph 30. This was an appeal from a small claim. The test there is you can award costs if there's been someone behaves unreasonably. Lord Justice Voss had indicated the Court of Appeal might want to give general guidance, and the full court doubts whether you can do that usefully, since it's so fact-sensitive. But importantly, they regard district judges and circuit judges as being able to derive helpful guidance from what Sir Thomas Bingham said in Whitehall. But the Upper Tribunal has just done exactly the same.
Yeah.
So that's the test. Is it unreasonable, having regard to all the circumstances and the facts of that case? Well, moving then to my third heading and pulling this all together, the tribunal had 2 days of evidence, further day of argument on costs. It is best placed. I'm not shying away from saying that. It's best placed to make a determination about whether the application was unreasonable. It didn't, in my respectful submission, solely treat this as a hopeless claim. It drew attention to a number of wider factors to do with the leases and other underlying disputes. It plainly felt its decision had given guidance for the future. It didn't think there was anything wrong in principle with using litigation to obtain that guidance. This court may well feel that that is a very generous decision in favour of my client, but it's not outside the generous ambit. The tribunal, the FTT, plainly asked itself the right test. It didn't elevate any kind of exceptionality test. It was plainly aware of what it considered unreasonable in this case because it made 2 orders. And as I say, as generous as I suspect this court feels it may be, it was not outside the generous ambit open to it. They did not err in law. They applied the test. Willow Court is cited and is helpful guidance to help them work through what's unreasonable. They identified the unreasonable behaviour. They punished it appropriately. And for those reasons, respectfully, we say the appeal should be dismissed. This was a decision open to them. They asked themselves the right question. See my Lord drawing breath. My Lords, I'll just turn my back so there's nothing else.
Yeah, no, please do.
No, my Lords, unless I can help with anything else.
Could I ask one question? How do you pronounce, first of all, the name of the case?
I pronounced it Whitehall.
Whitehall.
I could well be wrong.
Very English.
Ridehall.
Ridehall, apparently.
Right. I said Ridderhall before, and my lord, when we were outside, and my lord looked at me as if I was away with the fairies. So
I just ducked. And didn't commit myself one way or the other.
yes.
So,
Ridehall.
Ridehall.
I'll die on that hill, yes.
3 stages. The first raises the objective standard question, and it's under that heading, as my lord has said already, that the question of perversity falls to be determined. If, for the sake of argument, after reflection, the court were to conclude that the decision was tainted by perversity, the court would be entitled to take the decision for itself, would it not?
You certainly have that jurisdiction. You have all the powers of the lower tribunal.
If the court were to do that, and you then move to Ridehall Stage 2, discretion, would there be any sound reason for not making an order for costs if the court concluded the behaviour was unreasonable? I've not seen anything in your skeleton which addresses that aspect, and I asked the question because we were told about the Chancery proceedings, which, if relevant, might go to that, but query, do we reach that if you accept that there's no sound reason for refusing to make an order for costs if we conclude that this was unreasonable behaviour on the findings reached by the tribunal?
So I think the difficulty here arises because we didn't put anything in below at either the FTT or the Upper Tribunal. I don't see it's a proper use of a respondent's notice to put evidence in, which is primarily what we would have been seeking to put in, because it would seem to me that if we reach that stage, the critical question is mitigation. Is there some reason why we did what we did? I struggle to see how I can do that on a respondent's notice. If you are of the view that the tribunal erred at stage 1, so that there was unreasonable behaviour, my submission on relief would be remit to the FTT for it to carry out either all 3 stages afresh, if you conclude that, it may be the last 2 stages, if you conclude that no one could possibly find this to be anything other than unreasonable. But my submission would be remit to the FTT, because it is best placed to exercise that discretion in the light of the whole of the case that it heard.
Same FT, same constitution of FTT, or a different one? Because if it's a different one, what's the advantage?
No, so my suggestion would be to the same constitution. If not possible, President of the Tribunal to see how many of the members are available and reconstitute. I don't know if each of these 3 members are still tribunal judges or not. But my starting point would be back to them. This is a sufficiently unusual case that one imagines they'll remember it.
Because the behaviour was oversight.
Well, for a whole range of factors that I've pressed in aid over the last hour or so.
But this, if I've followed the analysis correctly, this arises because you feel, in the circumstances of this case, constrained such that you couldn't have put in a respondent's notice.
I don't think I can put a respondent's notice
on the basis
evidence.
That your client didn't participate in the discussion and making submissions before the FTT, which would have been the proper place to do it.
Agreed.
So this is a submission which doesn't sit comfortably, does it, with the finality principle? You're getting a second bite of the cherry.
Not necessarily. It's a first bite at the properly constituted cherry, because this court would have determined that the tribunal started to go wrong.
Yes, but even there, your client didn't help the tribunal on that point.
It chose not to be represented. I don't know why it made that choice.
And it's even more peculiar because, well, but no, perhaps it's become clear by that stage, because although they'd allowed Mr. Gubbay to act as their representative substantively, by the time we get to the costs argument, Mr. Gubbay is representing himself. And that deals with the conflict.
And there's an application against him personally.
Yeah.
So.
But then it should have been clear to the company then that it had to defend its own position.
I'm reluctant
just as it is in this court.
So I am reluctant to fall back on the time honoured. I'm afraid I have no instructions, but I'm afraid I have no instructions. Yeah. On the question of relief, given if you take the view that the FTT should have found that the first stage was met, and this is so obviously unreasonable that no properly directed tribunal could come to any other view, we still have the second and third stages. Firstly, as a matter of discretion, should an order be made? Thirdly, if so, in what amount?
Forgive me I'm just for interrupting, but you talked about the possibility that further evidence might be put forward. But if we were to imagine that, any such further evidence might actually go to the first question. It wouldn't necessarily be ring-fenced and only relevant to the discretion. It might go to the question as to whether they've been unreasonable at all.
Well, if this court finds that the only proper conclusion is that we were unreasonable, that's binding between the parties. I don't see how I could reopen that. I may nonetheless have mitigation.
I was wondering that too, in which case I do wonder whether the second stage is just purely a matter of submission.
It may be that this ties in with any decision you make about the Chancery proceedings. Because on one view, were they to be let in, it would seem fair to have a chance to at least answer those. I think I come back to where I started 5 minutes ago. My primary submission on relief, if you're against me, is remission. The FTT to carry out stages 2 and 3. My Lord.
No, sorry, I was interrupting you, Richard.
No, I think that's a good point to stop.
If we make a finding that the worst finding from your position, which is that this whole proceedings was unreasonable and so on, then I would respectfully ask my Lord's question again, which is, on what basis could you argue against an order in principle for the costs of the proceedings to be paid by your client to the appellants? And that's a matter of submission. We may have to, if we then said, okay, we're going to make an order that you pay the costs of, then to be assessed if not agreed, that's the way through, isn't it?
So
the question, the reason I interrupted you so rudely was, if we make the decision that you don't want us to make, namely that the whole thing is completely unreasonable, what do you say?
At that stage, I say stages 2 and 3 still need to be carried out, and there's a decision about forum, here or FTT. I say remission, because the second stage, what is the appropriate order in all the circumstances, is best determined by the tribunal that heard all of the circumstances.
If we make the finding, if we make the crunch finding that you don't want, at the moment, it may be my fault, but I don't understand what, in principle, is better for the FTT than for us.
Because the FTT may still regard. So in this hypothetical, you've concluded that the factors the FTT drew attention to as not justifying an order aren't sufficient. It may still regard them as powerful mitigation, and it should be the one to judge the weight that it gives to the factors.
The problem with all of this is it's all theoretical, as if we remitted it, there would be no guarantee that your clients would participate at that stage or in the UT, and we'd be back here in 18 months' time.
That must be a risk in all remission cases.
Yeah. Okay. Right, anything else? No? Thank you very much, Mr. Bates. Mr. Hutchings, do you have anything in reply?
My Lord, just really one point, if I may, just in relation to the what I would say was the utility or otherwise of the substantive judgment.
Yeah.
And it's really, my Lord, just to point out that in paragraph, maybe this is already familiar, but page 97, just to reiterate the point that paragraph 67, the finding that the demands are invalid, and the fact that the tribunal did not look to determine a reasonable amount, not least because of the lack of evidence, but also given it would seem to be a pointless exercise. Mm-hmm. So when considering whether or not these proceedings achieved anything substantive, it's clear that the tribunal took the view that they didn't and couldn't. And the point about pointless exercise, it's not quite clear what they meant there. Either they meant because of the failure to disclose any information, or possibly they meant that there was some evidence that the applicant didn't intend to carry out the major works. And so either way, looking at the result of the proceedings, there was no proper finding of any relevance to the parties. As regards the small questions that were answered, my Lord Justice Holgate made the point that the application under 27A3 could have been made as an entirely theoretical exercise, as a question of construction of the lease.
Well, like a preliminary issue.
Yeah, but that's the way to proceed, and often it is the way that it's proceeded.
And it's a way of saving costs in relation to the computation.
Precisely, because as soon as you serve a demand, you're into conflict about the amount of the demand. So the appropriate course to take is to get a binding determination about what the lease actually means. And finally, just to be clear, a point that I think's already been made, which is that in that substantive hearing, clearly the tribunal were trying to assist the parties as much as they could. But on the question of issue estoppel, in paragraph 104 onwards, the tribunal didn't make findings. They simply commented. And that, in my experience, is something that the tribunal are apt to do, not to make findings sometimes, but to comment on matters in order to try and assist the parties. But certainly those weren't binding findings of any utility.
Yes.
My Lord, unless there's anything further.
No, that's very helpful. I think that we may just need to rise to consider the question of this other judgment, because Mr. Bates has very properly set out his position in relation to that. So hang on a minute there, but we'll just rise and see what we want to do about the Chancery judgment. It was in the Chancery Division.
Commercial Court.
Oh, it was Commercial Court. It was because it was Mr. Justice Foxton. Yeah. Just hold on there, and we'll consider that point and come back.
All rise at table. Court rise to favour.
Thank you both very much. Mr. Hutchings, the position that we've reached is this. Our present view is that we will not look at or consider the commercial court judgment, and that we will make our decision on this appeal on the material that we have. If, on reflection, you still think we should, and you want to make submissions about it, you can make submissions limited to 2 sides of paper by the end of Monday. Mr. Bates can respond within 24 or 48 hours. But our present view is that in all the circumstances, we do not think that we are going to be assisted by looking at the decision in the leasehold or on the leases. So that's our view, but as I say, consider it, and if you do want to, as it were, challenge that, then by all means do, and that's the mechanism. If you conclude that you don't, I would be very grateful if you would notify my clerk, simply so that I know for the overall management of the appeal and the production of the judgments and so on.
Yes, my lord. I didn't get the date as to when you require that.
So say again.
Did you say by Monday?
By Monday, by 4 p.m. on Monday, I would want written 2 pages of, no more than 2 pages of submissions as to why you say we should consider it. And if you decide before that you don't,
Nil return.
I would be grateful to be told.
Yeah.
All right?
Thank you.
Possibly an abundance of caution, my lords, but if my learned friend takes that course, might I have permission to disclose his submissions to those who act for my client in the other proceedings? Because they may wish to take carriage of any response.
Well, I think you probably can, yes, but I would still limit the time for response to not more than 40 hours, so 4 p.m. Wednesday, because obviously it affects the John. I'm sorry if we do get into that position, but I've just got to try and manage this as best I can.
I completely understand, my lord. I'm just conscious that my client may consider that someone other than me should deal with it.
Yeah, I understand. Fine. All right. Well, thank you both very much, and thank you very much for the very efficient way you've dealt with the oral submissions. You won't be surprised to learn we're going to reserve our judgments. You will be notified in the usual way when the draft judgments are ready. They will be provided to you as drafts. They are then an opportunity for you to correct any spelling mistakes or grammatical errors. They're not, obviously, an opportunity to re-argue the case. You will get the judgment as a draft. It is a draft. It will go only to the people on the list that my clerk has been notified about, so it can't go to anybody else. And as you are both aware, strict rules as to disclosure and potential contempt of court now apply to draft judgments. So please treat them as drafts. Once you have, and at the same time as commenting on any typos, we would ask you to agree on an order arising out of the judgment. If you can, provide that at the same time. If you can't, if there's a particular point or points on which you can't agree, then the best thing to do is to provide an order with the competing parts of the order in different colours so it's clear what they are, and short, and I mean short, written submissions as to why you say it should be X, not Y. The judgment will then be handed down remotely, electronically, and there won't be any need for any further attendance.
Thank you.
Thank you both very much.
Court rise in favour.